the Whistleblower Protection Act of 1989, Pub.L. 101-12 as amended, is a United States federal law that protects federal whistleblowers who work for the government and report agency misconduct. A federal agency violates the Whistleblower Protection Act if agency authorities take retaliatory personnel action against any employee or applicant because of disclosure of information by that employee or applicant. Whistleblowers may file complaints that they believe reasonably evidences a violation of a law, rule or regulation. Gross mismanagement, gross waste of funds, an abuse of authority, or a substantial and specific danger to public health or safety. Authorized federal agencies, the Office of Special Counsel investigates federal whistleblower complaints. In October 2008, then Special Counsel Scott Block resigned amid an FBI investigation into whether he obstructed justice by illegally deleting computer files following complaints that he himself had retaliated against employees who disagreed with his policies. Then Senator Barack Obama made a campaign vow to appoint a special counsel committed to whistleblower rights. It was not until April 2011 that President Obama's appointee Carolyn Lerner was confirmed by the Senate. The Merit Systems Protection Board, a quasi-judicial agency that adjudicates whistleblower complaints, uses appointed administrative law judges who often back the government. Since 2000, the board has ruled for whistleblowers just 3 times in 56 cases decided on their merits, according to a Government Accountability Project analysis. Obama appointed a new chairperson and vice chairperson with backgrounds as federal worker advocates, but Tom Devine of GAP says, it's likely to take years for them to turn things around. The Court of Appeals for the Federal Circuit, only court empowered to hear appeals of whistleblower cases decided by the Merit Board, has been criticized by Senator Grassley and others in Congress for misinterpreting whistleblower laws and setting precedent that is hostile to claimants. Between 1994 and 2010, the court had ruled for whistleblowers in only 3 of 203 cases decided on their merits, GAP's analysis found. Legal cases: the U.S. Supreme Court, in the case of Garcetti v. Kebelos, 04-473, ruled in 2006 that government employees do not have protection from retaliation by their employers under the First Amendment of the Constitution when they speak pursuant to their official job duties. The U.S. Merit Systems Protection Board uses agency lawyers in the place of administrative law judges to decide federal employers unregistered trademark whistleblower appeals. These lawyers, dubbed OE attorney examiners, deny 98% of whistleblower appeals. The Board and the Federal Circuit Court of Appeals give great deference to their initial decisions, resulting in affirmance rates of 97% and 98%, respectively. Whistleblower Protection Enhancement Act and Presidential Policy Directive 19, the Whistleblower Protection Enhancement Act of 2012, Pub.L. 112-199, made many revisions to the Whistleblower Protection Act. According to the legislative history for S. 743, which ultimately became Pub.L. 112-199, federal whistleblowers have seen their protections diminish in recent years, largely as a result of a series of decisions by the United States Court of Appeals for the Federal Circuit, which has exclusive jurisdiction over many cases brought under the Whistleblower Protection Act. Specifically, the Federal Circuit is wrongly accorded a narrow definition to the type of disclosure that qualifies for whistleblower protection. Additionally, the lack of remedies under current law for most whistleblowers in the intelligence community and for whistleblowers who face retaliation in the form of withdrawal of the employer unregistered trademark S security clearance leaves unprotected those who are in a position to disclose wrongdoing that directly affects our national security. Additional whistleblower protections for intelligence agency employees were ordered by President Barack Obama in Presidential Policy Directive 19 in October 2012. Related legislation: on July 14, 2014, the United States House of Representatives voted to pass the All-Circuit Review Extension Act, a bill that would extend from 2 to 5 years after the effective date of the Whistleblower Protection Enhancement Act of 2012, the period allowed for filing a petition for judicial review of Merit Systems Protection Board decisions in whistleblower cases, and any review of such a decision by the Director of the Office of Personnel Management. See also. References. External links, Whistleblower Protection Act information. U.S. Securities and Exchange Commission. January 30, 2004. Retrieved May 3, 2007, OSC Form 11 for filing a whistleblower retaliation complaint.